This podcast is brought to you by the American Enterprise Institute.
If you like what you hear, please subscribe, rate, review, and share.
Thanks for listening. Here's our show.
What in the hell's going on?
What the hell is going on?
What the hell is going on?
I don't know what the hell he's talking about.
You don't have to know what the hell is on it.
What the hell's the matter with these guys?
We don't know what's going on.
What the hell's going on?
Who in God's name knows what it's all about?
Hi, I'm Danielle Pletka.
And I'm Mark Thiessen.
Welcome to our podcast, What the Hell is Going On? Mark, what the hell is not going on this week?
We're just careening from issue to issue in this country. My gosh, we just had a constitutional crisis with the President of the United States, who probably should be removed under the 25th Amendment. And now we've got a Supreme Court decision on presidential immunity that has roiled our political system. What do you think, Danny?
You know, I think that in a normal year, in a normal century, we could have a really, really interesting conversation about the implications of this Supreme Court decision. And frankly, all of the Supreme Court decisions that have come down over the last couple of weeks. You know, for those of us who have watched the shape of our government change over the last few decades and seen the growth of the administrative state, the growth of the education department and the EPA and all of these fake commissions that have been created, I think a lot of us would have looked at the court and breathed a sigh of relief that, in fact, the court is returning our government to its constitutionally mandated separation of powers and checks and balances, right? That is how I feel.
That's exactly what it's doing.
Right. But we can't have that conversation because everything is so hopelessly politicized that the second you put the word Gorsuch or Alito on it or Trump on it, we can't have a normal conversation anymore. So we can't have a normal conversation anymore about what the court just did.
Well, what the court just did was the result of what you're describing. I mean, the people are saying, why is the court making this decision in the first place about presidential immunity? It's never been an issue before. It's only an issue because of the politicized prosecutions that are taking place right now. We've never had a president prosecuted, former president prosecuted for alleged crimes committed during his presidency. And so the court has never had to question, well, what are official acts? What are unofficial acts? Where does immunity stand? Because it wasn't an issue until this all happened. And the other thing I think that has been lost in this debate over the immunity issue is the court has basically said that the checks and balances the founders put in place actually are the right ones. It's Congress's job to hold the president accountable for his official acts. He can be prosecuted for unofficial acts. And the fact that we're even debating what's an unofficial act, what's an official act is just a disgrace. But, yes, if the president of the United States goes out on the middle of Pennsylvania Avenue and shoots somebody, that is an unofficial act, and he can be prosecuted for that. And if he commits a crime, if he takes a bribe, if he tries to launch a military coup, these are things that the Congress should be addressing through its power of impeachment. And, so it's just, I think the decision is so common sense that absent the insanity that we're experiencing in our country today, it would be completely uncontroversial. But it's controversial because everything centers around stopping Donald J. Trump from ever assuming the powers of the presidency again.
Right. And I mean, at the end of the day, that is right. Everybody in the government, on the left, in the Democratic Party, has decided that their power has been given to them by the people of this country for one purpose and one purpose alone, and that is to stop Donald Trump. But I will say, not to come back to last week's podcast or earlier this week's podcast, but if that is the most important thing, if you are willing to suborn your responsibilities, your democratic responsibilities to the American people, because you believe that Donald Trump is the greatest threat to the constitutional order that has ever been faced in our almost 250-year-old history, then what the hell are you doing with a senile man running for office, right? I mean, if this is the most important thing on the face of the earth, that you are willing to take your oath of office and you are willing to pervert it in order to prosecute Donald Trump, because he is the worst thing ever, 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 then why would you take this chance by running an 81-year-old, obviously, increasingly senile old man in office? It's just the whole thing, all of our public discourse has just, everybody's lost their minds.
It has, and I'll tell you the other thing is, there was a really interesting swing state poll that came out that the Washington Post did, which found that large majority, I don't have the numbers in front of me, but large majority of voters in swing states think that democracy is in fact on the ballot, and a majority of them trust Trump to defend democracy more than Joe Biden. And the other finding that in that poll, which was fascinating, is that they were asked, I don't have the framing of the exact question, but basically, are you worried about a dictator coming to power in America? And most people said no, because they trust our institutional guardrails to prevent that from happening. Well, you know what? Maybe the reason why swing state voters don't trust the Democrats to protect democracy is because the Democrats are attacking the guardrails. Donald Trump is, most people, I think, correctly assume that if Donald Trump got elected and tried to assume a dictatorship, that our system would stop him from doing that. But they don't want to tear down the guardrails that stop a president from doing that. This is the problem with what the Democrats' strategy seems to be, which is that our democracy, Donald Trump is such a threat to our democracy that we need to burn our democracy down in order to save it. And most Americans don't want to burn our democracy down. They think our democracy is just fine. So yes, the president does have immunity for official act.
And not for unofficial.
And it's not about Donald Trump.
Can I ask you a question?
Sure.
We get into this with our guest. Do you think that when Donald Trump picked up the phone to call and create electors in Georgia, that he was committing an official act?
I have no idea, Danny. No, no, I don't think he did. I think that, and as our guest points out, his own lawyers said that he wasn't. That was not an official act. But
I guess the reason I asked you that, Mark, is because
I don't know. So the call in Georgia is different, because you can look at that call in Georgia, and what he said in that call in Georgia was not, I want you to go and change the numbers and do something nefarious. He was saying, he thought that there was fraud, and therefore he wanted the state of Georgia to find the missing votes that the Biden administration had stolen. I think that's cockamamie but I don't think I don't think the phone call in Georgia was criminal. But is it an official act? No, it's probably not an official act. It's the president of the United States as a candidate for president pursuing his political interests, not committing an official act on the part of the presidency. On the other hand, if he tells the vice president of the United States that he has a cockamamie legal theory in which cockamamie legal theories are not criminal. And if he has a cockamamie legal theory in which the vice president can send the election back to the states, and he conveys that to the vice president, that is an official act. And if he goes out and gives a speech expressing his views on that as the president of the United States, that is an official act. And that's protected not just by official acts, but also by the First Amendment. So, you can't criminalize everything. We talked about this a while back when it came to the Russia.
That's true.
We talked about this when we talked about the Russia issue many, many years ago. Having a dumbass Russia policy is not criminal, right? Saying that Putin is a great guy is not criminal. It may be terrible, but not everything is a crime, and not everything has remedy in the courts.
So our listeners won't be surprised to know that I disagree with a lot of what you just said. I agree that not everything is prosecutable. I think a lot of what Donald Trump did was a danger to our guardrails. I think a lot of what Donald Trump did was criminal. I think Donald Trump should have been impeached, like our guest thinks Donald Trump should have been impeached, had the articles of impeachment been written appropriately. The problem for us is the one that you always bring up to me, and with that we should probably turn to our guest, and that is our choice is not between Donald Trump and someone better. Our choice is between Donald Trump and Joe Biden, and that's the choice we're faced up to. So I neither forgive nor excuse what Donald Trump did on January 6th or thereafter, or claiming the election was stolen and everything else, but I worry a lot about having a president who is no longer functioning.
So there's the one area where I disagree with you on. So and I've said this before on the podcast, but I'll repeat it. On January 6th, our institutions held, right? All the checks and balances held. The vice president did his job. All the judges did their jobs. Nobody agreed. No, Donald Trump didn't win a single case, including the Trump-appointed judges. The state legislatures did their job. The electors did their jobs. The Congress did their jobs. And if any one of those had not done their jobs, there were fail-safes within the system for the others to do it. There was no chance that Donald Trump was going to stay president on January 20th, 2021 at afternoon, because the system wouldn't allow it, because there were so many safeguards in the system. When we threaten the safeguards, when we tear down the system, when we have people talking about packing the court so that we can change and getting rid of the filibuster, and using the Constitution to take him off the ballot, and prosecuting him for crazy legal theories, for using the legal system to try and bankrupt him for the crime of running for president through civil suits, this is all a bigger threat than Donald Trump is. Even if you think the worst of what Donald Trump
That's what the American people are going to need to decide. That's
absolutely
for damn sure.
And that's who should decide it. By the way, not judges, not juries. The American people should decide it. I agree with you on that.
Well, that is for sure. Our guest, recidivist, actually competing with former Representative Mike Gallagher for the number of times he's been on our podcast, is our good friend Andy McCarthy, better known as Andrew C. McCarthy. He's a senior fellow at National Review Institute. He's a National Review contributing editor. He's the author of a book called The Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. And especially because we're also talking about court cases in New York, we should remember that he served as an assistant U.S. attorney for the Southern District of New York.
Here's our interview. Welcome back to the podcast.
Great to be with you both.
We seem to keep having events occurring that require your expertise. And the most recent is the Supreme Court decision on presidential immunity. Just walk our viewers through. There's been so much hot rhetoric about this thing. Walk us through what this decision does and does not do, and why it's it's actually a very measured, careful opinion.
Yeah, I think it puts the brakes on something that should not have been rushed in the first place. And I think because of the charged politics of all this, everybody keeps looking at it as a Trump case. And I thought the court was very clear during oral argument in particular. Gorsuch famously said, we're writing for the ages. What they were concerned about most, I think, is the institution of the presidency, rather than how all of this particularly affects Trump. And it's unfortunate that all the political people who reacted to it, because the things that they say about it, you can't expect that most people are going to sit down and read a 100-page legal opinion. So they're going to rely on a lot of people in politics to sort of bumper sticker what the case is about. And I think, unfortunately, they're obsessed with Trump. And what the court is dealing with here is how to protect not only the presidency itself, but the equilibrium among the three branches of government. And what the court is really bound to deal with, which is hard to get people to sort of wrap their brains around, is our modern way of dealing with executive excess would be hard for the framers to believe. When the Constitution was designed, I mean, if you think about it, we didn't even have a Justice Department until about 1870. We didn't have an FBI until the 20th century. And the Constitution, the framers are very aware of the awesome powers that they're vesting in the presidency. And in order to check those powers so that they're not abused in a way that could be ruinous to the country, they vest Congress with a number of ways to check presidential power. And it would have been inconceivable to the framers that the main check on presidential power would become federal prosecutors who actually answer to the president in the chain of command. So I think what the court is trying to wrestle with is you have a constitutional structure that has one set of assumptions, and then you have modern practice, which is, I frankly think it's an unhealthy practice because it's atrophied Congress's muscles to deal with presidential misconduct. But the system is not designed for prosecutors to check the president. And the court is kind of trying to figure out a way to allow that to happen to the extent it might be appropriate to happen, but at the same time protect the framework of the Constitution. And I don't think it's easy to explain that to people because, for example, they say, and it's not crazy to say this, right? Trump, in an abusive way, put all kinds of pressure on Pence in order to do something that was blatantly illegal, namely use his ceremonial position basically to witness the counting of certified electoral votes and act as if he had a dispositive role and could discount the votes. Now, that sounds terrible, but try writing a rule that would regulate the communications between the president and the vice president without getting courts intruded in that on a regular basis, which the courts don't want to be because the president's dealings with the vice president in terms of the operation of the executive branch and the pursuit of the president's agenda in Congress are part of the core responsibilities of both the president and the vice president that the court shouldn't be second guessing. So I understand people's frustration. They say, look, we see this thing that happened, which was disgraceful and atrocious, and yet the court is saying that the court can't look behind it and the prosecutors can't look behind it. And I think those of us who are kind of originalist about the Constitution are saying, hello, Congress over here, your job to deal with the thing, the court's grappling with how do we let prosecutors do this? And the obvious answer is the system is designed for Congress to do it. There's nothing that prevents Congress from, all the things the court said that the prosecutors can't do. Look into the motives of the president, which is really the thing that's behind lawfare. I think if prosecutors now have to follow this rule that the Supreme Court has made, that they're not allowed to look into the motives of the president, if what the president is objectively doing is within his executive authority, you can't look into the motives of it. That's 8/10 of lawfare, right? But nothing prevents Congress from looking into it. Nothing prevents Congress from looking into the communications between the president and the vice president. All these things. So I think where the court comes out in a bottom line way, and even this is difficult to explain, but basically, it's if you think about it as concentric circles, there's a core of executive authority where the president has basically constitutionally assigned duties that the court has no business looking into. And a number of them are laid out. The pardon power, for example, is a core constitutional power of the president. Commander-in-chief power. The court lays out a number of them. That core, which they consider to be I think this is borrowed from Justice Robert Jackson in the steel seizure case, but it's considered to be the conclusive and preclusive authority of the president that the courts cannot look behind, and that Congress is powerless to enact legislation that will attrit or obstruct in any way. So that's clear enough. And even Jack Smith and the prosecutors agree that that can't be touched. And then radiating out from that, there's the president's authority that's in a kind of a gray area of the penumbra of his constitutional authority, the statutory powers that are imbued in the president because of various acts of legislation, and the interplay between the executive branch and the legislative branch, where it's not always where the, as they say, I think this is Holmes's expression, that the lines between the political branches are written in gray. There's not sharp divides between them where you can say that the president is necessarily treading on Congress's power or vice versa. And in those instances, what what the court says is the president has presumptive immunity. In the core area, it's absolute immunity. In the area around that, and they reach to what they call the outer ambit of the president's power. What they're going to say is that the president has presumptive immunity, but the way they write it, that's the kind of immunity that would be very difficult to overcome. They want the lower courts to examine this, And what they say about this is, we're not saying the president doesn't have absolute immunity even in that area, but what we're saying is it's enough to decide this case at this point where this inquiry hasn't even happened yet to say that at the very least, when he's in the outer ambit of his authority, the president has at least presumptive immunity. And what that entails, practically speaking, is all this has to go back to the lower court, and they have to do a very exacting analysis, probably with a lot of briefing and some hearings, to determine whether activities that are allegations in a charge, whether the actions behind them are official acts of the president so that they're within the ambit of the president's power, or private acts that are so obviously outside what the president's allowed to do that we can conclusively say that they're not part of presidential authority. Bottom line here, I think what the court was most angry is the wrong word, but I think most resentful about was that this thing was done in a big rush on an accelerated schedule. And what the court thought was the most important inquiry, namely this distinction between official acts and private acts, no one even tried to do it or even grapple with what rules should apply in trying to make these distinctions. Because Smith, and the court doesn't come out and say this, but it thrums through the whole opinion. Smith tried to get this case to trial based on the election calendar rather than what was right to do justice in a case where you're indicting a former president for the first time and making precedents that could cause damage to the presidency as an institution.
So there's so much brilliant analysis to unpack there. And of course, the court would have never had to take this issue on if it weren't for the fact that the first time we've had a president being indicted. So that's what forced the hand. But I wanted to touch on what you said about Congress, because this has been portrayed as strengthening the executive to a fault, right? In fact, it's a check on the executive in favor of Congress, because the Justice Department is a branch of the executive branch. And Congress already impeached the president for January 6th. He was tried in the Senate and acquitted. And they're effectively usurping the power of Congress and retrying him in an Article III court. And Supreme Court basically said, you probably can't do that. That's the job of Congress to sit in judgment of official acts. And they have almost unlimited authority to judge his official acts. Isn't this a strengthening of Article I over Article 2 and 3?
Well, I don't know if I would call it a strengthening. For example, one of the things I thought was wrong about Justice Sotomayor's dissent is that she talks about granting the president immunity. And I don't think the court is granting anything. I think the court is interpreting the system as it exists. And it's not really empowering Congress more than Congress is already empowered. I think what it's trying to say is that the way that this system is structured, Congress is supposed to be doing the heavy lifting here. But the court doesn't say, and they're emphatic about this, even though the commentary would not inform you about this. If, for example, and I think actually Justice Barrett is more whipped up about this than the majority is, but she drew from Trump's lawyer at the oral argument the concession that the fake electors scheme is private activity. It's completely office-seeking activity, not office performance activity, and it's all members of the president's campaign, and the activity that they're involved in has to do with the election, not any official actions of the president. Barrett says, this is obviously private. She elicited from Trump's lawyers at the oral argument that it was private. And I have to say, this is the first time I've ever seen, this is one of the things that took me back about the opinion. I've never seen a situation where a lawyer gives a concession that he had to have thought long and hard about before making, and the court kind of second guesses the lawyer in the opinion. The court comes around and says, well, there's a couple of things here, like there's some precedent about what President Grant did in the 1876 election. And, there's a couple of conversations that Trump has with some state officials, which really are not about the fake elector scheme, by the way. So I think what the court decided they wanted to do was they didn't want to break off any part of this. They wanted to send the whole thing back and tell the court to do all this fact-finding. But the reason I go off on this, Mark, is I think what they're saying is that where it's official activity, that Congress is the right place to check the president, but they're not saying everything's official activity. And I think they muddy the waters a little bit about something that's private. To me, anyway, I thought that was pretty clearly private activity. But what they're saying is if the prosecutors are going to get involved, it has to be something that's so obviously outside the president's duties that you can overcome the presumption and you can say conclusively that if we prosecute here, this is not going to compromise the executive branch in any way as an institution. That's basically the test that they're making, I think.
Thank you, Andy. I think this is actually a lot more confusing than a lot of people want to admit. I have two questions that are right bubbling at the top of about 100 others, and we won't impose that much on you. But my first question is, and this was brought up by our friends Sarah Isger and David French in their advisory opinions. What happens if the President of the United States, call him Donald Trump, call him Joe Biden, chooses to do something fully within his authority, grant a pardon, for example, but does it for money? In other words, accepts a bribe in order to grant a pardon. We saw Bill Clinton, by the way, do something on these lines with Mark Rich. Just so people understand, this isn't something that I'm imagining forward that Donald Trump might do. This is something that I think probably already happened. What do you think that means in light of this decision? And then I have a second question.
The message out of this is the main check on that would be impeachment. It's not really a practical check. I mean, we're in such a different place from when the Constitution was originally ratified that, to say that if you have a corrupt pardon, we'll take care of that with the impeachment pardon. Well, the impeachment clause was written at a time when the president wasn't term limited. The assumption wasn't going to be that the last thing the president did when he went out the door was pardon people. So I'm sensitive to the claim that and the argument that the impeachment clause is not an effective check on stuff that could be very abusive that a president does with his official authority as he's leaving office. I also think I happen to have been a prosecutor at the time that the Clinton pardons happened. In fact, I had a litigation that went on for about a year and a half with the terrorist Susan Rosenberg. We finally had to, convince a judge to keep her in prison to do her sentence, and then Clinton pardoned her on the last day. So we had an investigation after that, the Justice Department did, and I think the Bush administration made the right call not prosecuting Clinton because it would have been damaging to the institution of the president. These were very difficult questions to get through, including would it be proper to prosecute the president, given that a president doesn't have to have a reason to pardon somebody, right? You can pardon because it's Tuesday and I feel like pardoning someone. So interestingly, the court actually looks at this, and Justice Barrett raises it as well. And what I think the right answer to this is, Danny, is that they would kind of bifurcate it in this sense. You could prove the pardon. What Chief Justice Roberts says is you could prove the pardon because it's an official act. You wouldn't have to get into the president's deliberations over whether to issue the pardon or not. You could simply prove that it happened because a pardon's an official act, there's an official record of it. And what he says is what we're not going to tolerate is that you get behind all the discussions and the deliberations in the executive branch over the pardon. But on the other side of the equation, you can prove the bribe. And bribery is kind of a bright line in the Constitution because it's one of the predicates for impeachment. So you can conclusively say that, taking bribes is outside the powers of the presidency because it's a reason written expressly in the Constitution to remove the president. And that's the way you would have to do it. But having been through this, because I had a piece of that investigation that involved Hillary Clinton, it's a very fraught area. It's very whether we actually would have had a prosecutable case. I was on the side of people who thought we didn't have a prosecutable case, but it's a very close call. And I think the Bush administration made the right call not bringing it. I think that raises the bigger point that, to the extent that Trump says the president has to have immunity, to me, the big question was, does the president have to have immunity in the sense that the court has to explicitly say so? And I guess he does if we're going to be in an era of partisan use of prosecutorial authority where you may have more of these kinds of cases. But it is worth observing that we went through about 233 years without having to say that the president had immunity, and there were no prosecutions of presidents. Now, you could also argue there were no politicized prosecutions either, that wasn't a thing that we did. But we did go an awful long time without anyone saying that the president had immunity. And I think that was because everybody kind of understood that if you're gonna have the presidency as it's laid out in the Constitution, you can't be subjecting it to constant criminal prosecutions.
I agree. I mean, so much of this is I guess what we would call situational, right? Things that are, I always remember what John Yoo said to us on a previous discussion about some other legal issue with Donald Trump, that the founders would never have imagined to themselves that there would come a moment when there would be a president of the United States, a chief executive, who would not be so shamed by the prospect, not the actual act of, but the prospect of impeachment, that he wouldn't step down. And so, we have come so many light years away from that it is really hard to talk about. But I have my second question. So it's interesting. Obviously, at the end of the Supreme Court session, you have this barrage of opinions, right? And we have not talked on this podcast about the overturning of Chevron. And I don't want to talk about that too much, especially because even though I pretend to be a lawyer, I'm not actually. But one of the most important things to me about Chevron is that it really takes the power of the administrative state, the imperial presidency, if you want to use the favored language of the day, and it says, you know what? That's why we have a Congress. You don't get to do that with your administrative state, Mr. President. I'm taking away your power. Then I turn to this decision and I see the dissents and I see the comments from our political leaders, and it says, well, we're basically turning the president into the King of England again. And I guess what I don't understand is, I don't think much of Sotomayor, and I don't think much of Justice Ketanji Brown Jackson either. Elena Kagan is a very serious person, I think. And yet she is also part of this. Why are the dissents so situational and so not judicial in their nature? Help us understand that.
I don't know that I completely agree that they are, though, because I think there's a thread that runs through it. Like, for example, in the administrative state cases, what the progressives on the court always say, and I think they always get this wrong, is that this is a power grab by the court. When they second guess the administrators, they say this is the court coming in and saying they know best about like drug regulation and this regulation. And that's not what the court's doing at all. What they're doing is they're recalibrating or almost rebooting the system so that responsibility is moved to the place where it was supposed to be in the first place and where it's most accountable to the actual sovereign, which is the public. So they're taking power away from these unelected bureaucrats and they're saying, Congress, do your job. And then here we have this situation where we're trying to regulate presidential misbehavior by putting in charge of it not only now unelected bureaucrats, but actually inferior officers of the executive branch who, in the org chart, they actually answer to the president. Now, we're talking about a former president rather than sitting president, but I think part of what the framers would have thought was wacky about this was the idea that you would, let's check the president's potential abuses of power by empowering subordinate executive officials to be the check, when what the framers did was say, no, Congress is the check. And I think, to me, Trump deserved to be impeached, removed, and disqualified. And it was for Congress to do that. And the fact that Congress didn't do that is a failure of Congress, but it doesn't mean that trying to accomplish it by alternative means is something that can either easily or rightly be done in the context of the system. If you're going to take Trump, this is part of the thing that drives me nuts with arguing this with old friends of mine, because a lot of people who are even good lawyers, it seems to me like they can't, especially when Trump's involved, but maybe it's all politics, but they can't put their like clinical lawyer hat aside. It's always got to be Trump, about Trump. And the thing is, if you want to treat Trump in the political process, it's impeachment and everything is fair game. But if you're going to take him and put him in the criminal justice system, then he's entitled to all of the rights and privileges of anyone who's in the criminal justice system. And for some reason, we understand that when the defendant is a terrorist, mass-murdering, anti-American jihadist, and everybody says, whoa, 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 we have to show how our system shines. We have to give him all of the majesty of the Bill of Rights and be a shining example to everyone of how this really works and how this system is the envy of the world. And then when the defendant is Trump, it's like, what do you mean due process? We don't need that. I think it's crazy. But I'm digressing. I think the point is, I think the court is moving power back to where it belongs, and progressives don't like that because they like the way power has evolved. So obviously the three progressive justices here think it's fine and dandy for prosecutors to be able to do what the prosecutors are trying to do here. And Mike Dreeben, who's a very good lawyer, I knew him back in the days when he was in the Clinton Justice Department. He was representing Jack Smith in this case in front of the Supreme Court. He's got this whole idea of, you don't need immunity because, first of all, we have all these internal safeguards in the Justice Department. We have the Justice Department is committed to apolitical enforcement of the law, and we have grand juries, and we have, all these internal safeguards. And I remember thinking when Dreeben was making that argument to the court that if you looked over to the other table, Trump wasn't there, even though he wanted to be there, because he was on trial up in New York in one of those politicized prosecutions that prosecutors don't do, So he had this idea, though, Dreeben did, that, we have all these internal safeguards, and you don't have to give a president immunity because the president can make an as-applied constitutional challenge under Article 2 to try to prevent evidence from coming in and get charges wiped out. And that would have the burden of proof then would be on the president to show that the introduction of evidence or the prosecution of charges would harm the presidency and would be unfair in the four corners of the proceeding. And what I think that the majority of the Supreme Court is saying here is, no, that's putting the burden in the wrong place. What we're saying is he's got presumptive immunity. And what that means is it's not necessarily absolute immunity, but the burden's on the prosecutors to come forward and explain why it is that this ought to be permitted. But the message underneath it all is Congress isn't bound by any of this. If Congress wants to impeach him, they can do all the things that the court is saying the prosecutors can't. And I think that's just kind of moving the power back where it belongs.
So just a footnote, and I agree with you totally. Just a footnote, because I think I probably expressed myself badly. What I was really trying to ask was, if Donald Trump wasn't or hadn't been the president, if this was in the 1990s, would the three progressive liberal justices have objected to this decision?
It's a hard what if, because I think things have changed to the extent that I don't think either the Clinton or the Bush administration would have walked down this path. I don't think either one of them would have indicted a case like this. And there's a vogue for politicized prosecutions. Danny, this is like the example I've used like a million times because this is where it hits home to me. In the 1980s and 90s, when I was a prosecutor in New York, I was federal, where it's an appointed system. But across the street was Bob Morgenthau, who was forever and ever the district attorney of Manhattan, right? Now, that's an elective office, and he had to run for it like every 4 years or whatever. But of course, he always ran unopposed. But if he had campaigned for office saying, elect me and I will use the powers of the office against our political enemies, that would not only have been disqualifying, I think they would have run him up to Bellevue for evaluation. And today, Tish James and Alvin Bragg run for office and they say, elect me and I will use the power of the office against our political enemies. And they get elected in a landslide, which to me, that's a cultural thing more than a legal thing. But I do think it reflects a big change in things, and it's not a change for the better.
So this case, as we've discussed and you've raised, is prompted by the rise of political prosecutions, but it's also has to do with the rise of political impeachments. So, the response to this is a practical one, not a legal one. From some people will say, well, you can't depend on Congress to impeach the president because look, they acquitted Donald Trump and he was so obviously guilty, and they forget the first impeachment. Which affected the second impeachment, didn't it? The first impeachment was an absolute political exercise and an atrocity. And that certainly colored how people responded in the second impeachment in the Republican side. It used to be the idea would be that you wouldn't impeach a president unless there was clear bipartisan understanding that the president had committed high crimes and misdemeanors. You wouldn't even impeach him and have a trial. So isn't this another effect of Trump derangement? Is that the impeachment response doesn't work because the Democrats have politicized that as well.
I think, Mark, they would say that this all goes back to the Clinton impeachment, in the sense that the Republicans went ahead and impeached Clinton. And I say this as somebody who thought he had committed impeachable offenses. And I think if Clinton's misbehavior had become public early on, before, Carville and Begala and all those guys spent 8 or 9 months doing character assassination on Ken Starr, if like in the assumptions of 1994 or 1995, it became clear what Clinton had done, I think in that famous conversation that he had with Dick Morris, he would have had to resign because the sensibilities of people back then would have been he'd have to leave office. But I think by the time the Republicans pulled the trigger on impeaching Clinton in 98, it was already clear that they would never, ever have the votes to remove him in the Senate. And in the House, they kind of said, we need to do this anyway. And if you're impeaching the president that you don't have any chance of removing,